Imagine working for 2 entire years, living in a tiny flat right above your workplace, and not only making $0 in wages, but actively draining your own disability pension just to pay for your boss's overseas family holidays.
It sounds like something out of a 19th century sweatshop, honestly. But it actually happened in Sydney, Australia in 2023.
Right. It's completely wild.
Yeah.
Welcome to today's deep dive. We are taking a really hard look at the extreme edges of workplace power dynamics and employee rights.
Exactly. And to do this, we're unpacking a really fascinating stack of sources from Australian workplace discrimination representatives, or AWDR.
Yeah, they're a firm of non-lawyer workplace relations specialists, right? They represent employees in disputes, and they share some incredibly revealing case summaries with us.
Our mission today is to, well, look at two highly contrasting Fair Work cases. We really want to understand the actual mechanisms the legal system uses to protect vulnerable workers.
Because most of us just want to go to work, do our jobs, and go home. But these sources reveal what happens when that fundamental trust just completely evaporates.
It gets dark, really dark, and it shows what you, the everyday employee, actually need to know about navigating your rights.
So let's start with that horrifying scenario I mentioned at the top. The case is Johnson versus Village Bakery Balgola Heights.
Right, so this case finalized late last year, in December 2025. Legally, it's categorized as a profound breach of trust, but honestly, that feels like a massive understatement when you look at the facts.
Yeah, the details are rough.
Yeah.
The employee, Tayla Madison Johnson, was a 16-year-old girl with a mild intellectual disability and ADHD.
She started working as a casual retail assistant at this bakery in June 2021. And for her first 3 weeks, she worked roughly 123 hours.
Okay.
And the employer paid her a total of $1,273.
Wait, doing the quick math on that, that's roughly $10 an hour, which, I mean, even for a 16-year-old sounds incredibly low.
Oh, it is. It's significantly below the legal minimum wage mandated by the Modern Award for her specific role.
Hold on, let's clarify that for anyone listening who isn't, deep into Australian employment jargon, what exactly does a modern award mean in practice?
Right, so think of a modern award as a legally binding industry rulebook. In Australia, it outlines the absolute minimum pay rates, penalty rates, and conditions for specific jobs.
So you literally cannot legally pay someone less than what their award dictates.
Exactly, regardless of whatever private contract they sign. But in Tayla's case, that initial $10 an hour was actually the high point of her compensation.
Oh boy, I'm bracing myself. What happened next?
After that first payout, Tayla received 0 wages for the remainder of her employment.
0.
Nothing at all. For nearly 2 years, all the way until April 2023.
0 wages for 2 years. But the sources show the exploitation didn't just stay at the cash register, did it? It actually bled into her living situation.
It did, in a very dark way. For 9 months of that period, Tayla actually lived in a flat above the bakery, sharing the space with the bakery's owner, New Vu.
And during that time, the owner forced this teenager to use her own disability support pension to pay for the bakery's commercial expenses.
Yeah. The boss required Tayla to pay for the commercial rent, to buy meat and supplies for the bakery.
Wait, a teenager's government disability pension was funding a commercial bakery's meat supply.
Yes. And it extended into the boss's personal life, too. Tayla was forced to financially contribute to the owner's personal overseas family holidays.
That is just, I can't even.
In total, she was drained of $18,080 from her pension. And when the employment finally ended, the boss even withheld her personal belongings.
It is genuinely hard to wrap my head around the psychology of this. I mean, how does a business owner operate in broad daylight, serving customers, while systematically extorting a disabled teenager upstairs?
It requires a terrifying level of calculation.
They must have just assumed she simply didn't have the resources to fight back.
Yeah. That is usually the core calculation in extreme exploitation like this. The employer banks entirely on the vulnerability of the worker.
Right.
But the legal fallout here is fascinating because it reveals a very specific mechanism built into the Fair Work Act to combat this exact kind of cover-up.
Because the business completely failed to keep any employment records, right?
Mm-hmm.
Or provide pay slips, which I imagine is the oldest trick in the book for wage theft.
Oh, absolutely.
If there's no paper trail, how can the employee prove how many hours they worked? It becomes a teenager's word against a business owner's.
Historically, yes. Employers would just destroy the logbooks and claim ignorance. But the Fair Work Act has this brilliant countermeasure.
Okay, what is it?
If an employer breaks the law by failing to keep adequate records or issue pay slips, the legal burden of proof actually flips.
So, well, wait, so instead of innocent until proven guilty, the court automatically assumes the employer is guilty of the underpayment.
Essentially, yes. The court assumes the employee's claims about their hours and unpaid wages are entirely true unless the employer can definitively prove otherwise.
That is like a legal dead man switch. By trying to cover their tracks and hiding the records, the employer actually weaponizes the law against themselves.
Exactly. They trigger an automatic presumption of their own guilt. It completely traps bad actors.
Because the bakery obviously couldn't prove they paid her since they hadn't.
Right, and to make it worse, the owner actively evaded court proceedings. She lied about her whereabouts to the court servers who were trying to deliver the legal documents.
So the court saw all of this, the missing records, the evasion, the text messages demanding pension money.
And they found a systematic pattern of conduct. The Federal Circuit and Family Court stated she knowingly took advantage of Tayla's youth and intellectual disability for pure commercial gain.
The language the judge used in the sources was striking, actually. They called it deplorable, but noted even that word wasn't strong enough.
Yeah, profound breach of trust was another phrase they used.
So how does the legal system actually punish something this severe? Because just making them pay the stolen money back, I mean, that isn't a punishment. It's just returning what was stolen.
The court recognized that exactly. They stated the penalty needed to have a sufficient sting to act as absolute deterrence.
So what was the final number?
The final financial penalty was massive, over $300,000 in total.
Break that down for us, because that is a staggering number for a local bakery.
Okay, so the business entity itself was hit with a $160,000 penalty. On top of that, the owner was ordered to pay $75,000 personally.
Wow.
Then they had to pay over $72,000 in compensation for the unpaid wages, superannuation, and the drained pension money.
Plus the damages for her belongings, right?
Yep. Over $18,000 just for keeping Tayla's personal things, plus legal costs specifically because the owner unreasonably evaded the court servers.
And the most crucial detail here, the court ordered those penalty amounts to be paid directly to Tayla, the victim.
Exactly. So the fines didn't just disappear into some government treasury. They went to the teenager whose life was derailed. It's a really incredible outcome.
It really is. But it's easy for the legal system to punish an employer when there are missing payslips, illegal rent deductions, and a clear-cut villain.
Right.
What happens when the legal system faces a dispute where both the employer and the employee have sophisticated legal arguments and, like, wildly conflicting versions of reality?
Well, that is where workplace law enters incredibly murky waters. Sometimes the Fair Work system isn't dealing with a simple missing payslip.
Right.
It's dealing with highly complex corporate battles where both sides allege severe misconduct, which brings us to the realm of general protections claims.
And the second case in our sources, McGreen versus 7 Network.
Yes. Yeah.
Now, this one is currently an active case playing out in the federal court.
Yes.
And the contrast from the bakery case is jarring. Let's start with the employee side of the timeline.
Okay, so the employee is Matthew McGrane. He was a prominent supervising producer for the 7 Network's breakfast program.
He worked there for nearly 25 years, and he is paraplegic, having used a wheelchair for over 2 decades.
Right. And working on a breakfast television program involves grueling, unusual hours. According to his legal claim, McGrane had a verbal agreement with the executive producer to leave his shift early at 9:20 p.m.
Specifically so he could catch a wheelchair-accessible bus home, because those buses stopped running at 11 p.m.
But on a rainy night in October 2023, while heading to that bus stop, the wheels of his chair caught on an uneven path and he was thrown to the ground.
The resulting injuries were horrific, according to the sources. He suffered a fractured arm, a detached triceps muscle, and facial injuries where his teeth scraped the pavement.
He required surgery and was off work for 10 weeks.
And while he was recovering from surgery, his workers' compensation claim was completely denied.
Why? Because the 7 Network told the insurer that no formal early leave agreement existed.
Wow. He was essentially told he shouldn't have been leaving at that time, which invalidated the claim.
He described feeling abandoned and in total disbelief. But the denial of the workers' comp claim is really just the first domino here.
Right, because the core of his legal action, his Fair Work General Protections claim, stems from what he alleges happened when he finally returned to work in April 2024.
Upon his return, he claims the network completely sidelined him. He alleges they stripped him of his supervisory duties, forced him to communicate with his team only via email.
They physically removed him from Microsoft Teams channels, right?
Yeah.
And passed him over for an executive producer role, giving it to junior staff instead.
Yes. So he filed a claim alleging adverse action and disability discrimination.
Let's unpack the mechanism of that claim for a second, because a general protections claim is very different from standard unfair dismissal, isn't it?
It is. Under the Fair Work Act, an employer is strictly prohibited from taking adverse action against an employee.
And adverse action isn't just firing someone.
No, it includes demoting them, altering their positions, their prejudice, or really just treating them differently in a negative way.
But it has to be tied to a specific reason. I mean, you can alter someone's position if they are just terrible at their job.
Correct. It becomes illegal if the adverse action is taken because the employee has a protected attribute like a disability or because they exercised a workplace.
Like making an inquiry about their pay or filing for workers' compensation.
Exactly. So McGrain is arguing a direct causal link. I have a disability, I had an accident, I filed a claim, and as a result, you stripped me of my duties.
Okay, let me push back here for a moment. It is very easy to paint the television network as a cartoon villain in this scenario, denying compensation to a 25-year veteran in a wheelchair and then demoting him.
Right.
But a massive corporation like the Seven Network has an entire fleet of employment lawyers. They wouldn't sideline the senior producer in such an obvious way unless they believe they had an ironclad reason.
You'd think so, yes.
So what is their actual defense? How do they justify the demotion?
That question is the pivot point of this entire dispute, and it's crucial to state that we are looking at this impartially. We're using this active case strictly to illustrate how general protections claims can escalate. Because the Seven Network's defense, filed in court, argues that the changes to his employment had absolutely nothing to do with his disability.
Or his compensation claim.
Right. They argue the causal link is entirely different.
What are they claiming was the actual cause then?
The network alleges that while McGrain was away recovering from his surgery, they uncovered serious pre-existing conduct issues.
Okay.
They claim staff under his supervision came forward to report what was described as a soul-crushing workplace culture.
Soul-crushing. I mean, that is incredibly strong language for a legal filing.
Right.
What exactly are they alleging he was doing to warrant that description?
According to their defense documents, junior colleagues claimed he frequently exhibited aggressive behavior. They alleged he was swearing, shouting, and harshly dismissing ideas.
Oh.
The network claimed that several younger female producers reported feeling unsafe and were often left in tears by his management style.
So they're painting a picture of a deeply hostile environment, completely separate from his physical disability.
It goes much further than general hostility, actually. Specific allegations of misogyny form a central pillar of the network's defense.
Really?
Yeah. They allege female employees provided feedback that McGrain made derogatory comments about television presenters. The network claims he told staff things to the effect of, "You look fat," and instructed them to wear a more low-cut top.
That is a wild pendulum swing from the initial discrimination claim. We've gone from a man seeking accommodations for his wheelchair to an employer alleging blatant misogyny and verbal abuse.
It's a massive escalation. The network also alleges his written correspondence was highly inappropriate. They claim he repeatedly used an extreme expletive, the C word, in professional work emails.
In work emails?
That's the allegation. Furthermore, they allege that during a phone conversation discussing his return to work, his behavior was so aggressive that he reduced a senior director to tears, leaving her physically unable to speak.
And there is a final layer to this, involving a television interview, according to the sources.
Yes, there is. The network claims McGrain breached his employment contract by participating in an interview on the ABC's Four Corners program.
Okay, what did he say?
While in their filing, they allege he collaborated with a journalist to intentionally disparage the network. And perhaps most damaging to his initial claim, if proven true, they allege he described the interview to others as an insurance policy.
An insurance policy for what?
To, quote, get millions from his employer.
This is fascinating from a legal perspective. I mean, how does a judge even begin to untangle this?
It's incredibly difficult.
On one side, you have a plaintiff claiming adverse action due to disability discrimination. On the other side, the employer argues the adverse action was entirely legitimate performance management based on uncovered bullying and misogyny.
The court basically has to determine the true state of mind of the decision makers at the Seven Network when they altered his duties.
Right. Was a substantial part of their reasoning based on his disability or his workers' comp claim? Or was it purely a response to the behavioral allegations?
Exactly. The two parties actually attempted mediation in late 2025, but it failed entirely.
So now it goes to trial.
Now the federal court will have to hear witness testimonies, subpoena emails, and reconstruct the reality of that newsroom.
You might be listening to this thinking, well, this is interesting, but I'm not a disabled teenager being extorted by a bakery owner, and I'm certainly not a television executive locked in a multi-million-dollar lawsuit.
Which is fair.
But the underlying thread connecting these two wild extremes is how incredibly fast structural power is leveraged the second a workplace relationship fractures.
That's the key takeaway here.
When an issue arises, whether it's a denied pay raise or a hostile manager, the employer immediately has the upper hand in terms of resources, lawyers, and systemic knowledge. Where does an everyday worker turn when that power dynamic turns against them?
Well, the Fair Work system is designed as a safety net, sure, but it is a highly technical, dense web of legislation, modern awards, and strict procedural rules.
The average person cannot just navigate it on their lunch break.
Exactly. And that is where the role of specialized representation becomes critical.
Let's dive into the information provided by AWDR. They are described in the sources as non-lawyer workplace relations specialists, right? With over 30 years of experience supporting employees.
That's right. And the list of disputes they handle is massive. Unfair dismissal, general protections, sexual harassment, toxic workplaces, non-genuine redundancy, and constructive dismissal.
Constructive dismissal is a particularly important concept for you listening to understand. It is a mechanism where you aren't officially fired, but the employer makes the working environment so hostile, intolerable, or legally precarious that you are essentially forced to resign.
Yeah, and legally, it is treated the same as being fired.
So, if these disputes involve such complex legal mechanisms, from reverse burdens of proof to untangling adverse action claims, why might an employee choose a specialized representative like AWDR rather than just hiring a traditional employment lawyer?
It really comes down to three main factors detailed in the sources: strategy, systemic expertise, and crucially, cost.
Okay, let's break those down.
Specialists like AWDR are laser-focused exclusively on the Fair Work Commission system. They aren't drafting wills on Monday and doing real estate law on Tuesday.
So their entire operational model is built around how these specific tribunals function in reality, not just in theory.
Exactly. Which means their goal is likely strategic negotiation rather than a protracted, messy court battle.
Right.
They emphasize early assessment, mediation, and arbitration. They aim for quick, effective resolutions.
Because the McGrain case we just discussed, which is dragging through the federal court, is incredibly exhausting and expensive for everyone involved.
Specialists try to resolve the friction before it reaches that point of mutually assured destruction.
And you mentioned cost, which has to be the biggest barrier. If you've just been fired, or if you're a teenager who hasn't been paid in 2 years, you don't have a $5,000 legal retainer sitting in your checking account.
That financial disparity is the exact leverage bad employers rely on.
Right.
Our sources explain that AWDR specifically structures their services to remove that barrier. They often assess claims rapidly, and in many situations, such as certain unfair dismissal or sexual harassment cases, they operate on a no-win, no-fee basis.
Or with no ongoing cost to the employee. That fundamentally alters the power dynamic. It really levels the playing field.
It does, because a large corporation has an entire HR department and a legal firm on speed dial. The everyday worker usually has no one.
Bringing in a specialist ensures that an employee who might not fully grasp the nuances of the Fair Work Act isn't simply steamrolled into accepting an unfair outcome.
It transforms a structural imbalance into a fair negotiation.
We have covered some really intense ground today, from the darkest corners of exploitation to the complex realities of corporate litigation. So to bring it all together for you listening, power dynamics exist in absolutely every single workplace.
They really do.
Most of the time, they're invisible, hiding behind friendly Slack messages and team lunches. But when things break down, you need to know exactly where you stand and what mechanisms exist to protect you.
Absolutely. And if there is one critical, actionable takeaway from our sources today, it is about time.
Yes, if you believe you have been unfairly dismissed, you have a strict, non-negotiable 21-day time limit to lodge a claim with the Fair Work Commission.
21 days. That is barely 3 weeks. It passes in an absolute flash, especially when you are paralyzed by the emotional shock and financial panic of suddenly losing your livelihood.
The absolute worst thing you can do is wait and hope things resolve themselves.
The system has powerful protections built in, like the reverse burden of proof that caught that bakery owner or the severe deterrence penalties. But those protections only activate if you know how to access them in time.
And looking ahead, reading through these sources raises a really fascinating, provocative question about the future of work itself.
It does. As remote work, flexible hours, and digital communication become our permanent reality, how will these legal definitions adapt?
Right, because when your living room is technically your office and your primary communication with your boss is via a screen, the boundaries of a workplace environment and reasonable accommodations become incredibly blurred.
The next major wave of fair work cases is going to have to define exactly where the employer's jurisdiction ends and the employee's private sanctuary begins.
It makes you wonder how a general protections claim will look 5 years from now when the alleged misconduct happens entirely in virtual reality or private chat channels.
Oh, absolutely.
The scale of employment isn't just unbalanced. The very items we're weighing on it are changing shape. Thank you so much for joining us on this deep dive. Keep asking questions. Pay close attention to the fine print of your own agreements. And most importantly, stay curious. We will catch you next time.